What is the California Office of Administrative Hearings? In California's Government Code, found in Title II, Division 3, Part 1, Chapter 4, there's established the Office of Administrative Hearings, otherwise known as OAH. And Article 1 provides its general provisions. First, Section 11370 specifies that Chapters 3.5, 4, 4.5, and 5 constitute and may be cited as the Administrative Procedure Act. In section 11370.1, it defines director to be the executive officer of the Office of Administrative Hearings, again, OAH. In section 11370.2, it establishes in the Department of General Services the OAH, and it's under the direction and control of an executive officer who is known as the director. The director is qualified and required to have the same qualifications as an administrative law judge, and the director is appointed by the governor and is subject to confirmation of the California State Senate. Section 1130.3 requires the director to appoint and maintain a staff of full-time ALJs, administrative law judges, which will be sufficient to fill the needs of the various state agencies coming before OAH. The director of OAH also appoints any other technical and clerical personnel as he or she deems required to perform the duties of the office. Thereafter, the director assigns an ALJ for any proceeding, and upon request of an agency, may assign an ALJ to conduct other administrative proceedings not necessarily arising under this particular chapter. The ALJs are deemed to be employees of OAH and not the agency. When not engaged in hearing cases, ALJs may be assigned by the director to perform other duties vested in or required of the particular Office of Administrative Hearings. In section 11370.4, it requires the total cost of the state of maintaining and operating OAH to be determined by and collected by the Department of General Services, DGS. And that has to be done in advance of or in a manner it may determine from the state or other public agencies for which services are provided by OAH. Section 11370.5 directs OAH to study the subject of administrative adjudication in all of its aspects, also to submit its suggestions to the various agency that it works with in the interest of fairness, uniformity, and expedition of business, and to report its recommendations to the governor and the legislature as well. Additionally, this section says that all departments, agencies, officers, and employees of the state are required to give the Office of Administrative Hearings ready access to their records and full information and reasonable assistance in any manner of research that requires recourse to them or any data within their knowledge or control. Article 2 deals with the Medical Quality Hearing Panel, which is a separate entity established within the Office of Administrative Hearings, and it's called the Medical Quality Hearing Panel, MQHP, which consists of at least 5 full-time ALJs, and they must have medical training as recommended by the Division of Medical Quality, which is a part of the Medical Board of California under the office, the Department of Consumer Affairs. Now, in this section, the director is required to determine the qualifications of panel members to supervise their training and coordinate the publication of a reporter of decisions. The panel must include only those persons specifically qualified, and it can't at any time constitute more than 25% of the total number of ALJs under OAH. Section 11372 requires all adjudicative hearings and proceedings relating to the discipline or reinstatement of medical board licensees to be conducted by an ALJ sitting alone if the case is assigned by the agency. Section 11373 requires all adjudicative hearings and proceedings conducted by an ALJ to do so under the terms and conditions set forth in California's Administrative Procedure Act. Section 11373.3 requires OAH to provide facilities and support personnel for the review committee panel and assess the Medical Board of California for its facilities and personnel. Article 3 then, which is the final article here, deals with state agency reports and form appeals. Section 11380 requires OAH to hear and render a decision on any appeal filed by a business in the event that that business contests the certification by a state agency head that reporting requirements meet established criteria and not be eliminated. In addition, before a business can file an appeal with OAH, the business is required to file a challenge to a formal report required by a state agency with that state agency again first. And within 60 days of filing that challenge with the state agency is required to either eliminate the form or report or to provide a written justification for its continued use. And finally, under section 11380, a business may appeal a state agency's written justification for the continued use of a form or report, and it does so by filing with the Office of Administrative Hearings. If the state agency fails to respond within 60 days of the filing of that written challenge, then the business has an immediate right to appeal with OAH.